Hi everyone, and we're looking at the substantive topic of murder and voluntary manslaughter, having previously covered actus reus, causation, and in the second video mens rea. So all of that we've been looking at so far will come into play in what is our first sort of offence that we're discussing. So as we move forward, just to say, if you find this video useful, please like and subscribe. But as we move on, usually I like to do some sort of puzzles with my class at the start. Feel free to pause the video and see if you know the answers to these as I just put up the answers now. Okay, well done if you got those correct. So moving into the offence, murder was defined by a 17th century judge named Lord Coke. Recently discovered that that's pronounced Cook and not Coke. And Lord Coke said in what is a common law offence, so this isn't statutory, this has come from a judge-made decision in a case. The actus reus, AR, and MR, as I've put there. Now in the exam, it's perfectly acceptable to refer to actus reus and mens rea as AR and MR. There is some abbreviation allowed to some extent. The other type you might be thinking of is D for defendant, which you've seen me use so far, and V for victim. But outside of AR, MR, D and V, you probably want to avoid using abbreviations thereafter. Names of statutes, you should put in full first. Try to remember the year of the statute if you can. No need to know the year of the case, really. I think the only point at which some relevance there is judicial precedent as a topic, perhaps knowing which cases came first along the timeline for the practice statement. But yeah, no need otherwise to know the years of the cases. And so anyway, back into murder. Actus reus is the unlawful killing of a reasonable creature in being, and the mens rea is under the now kings, of course, under the king's peace, with malice aforethought express or implied. And so when you are writing about this in the exam, you will need to explain what these terms mean, and we're going to look at that now. So just as a reminder and link to what we've previously done, the actus reus, the guilty act, the physical element of a crime, here is the killing. But it's worth remembering that the killing can be done through an act or omission. So, for example, we said before in a video that if I had a gun and pointed it at somebody's head and pulled the trigger, that is clearly an act of the defendant. I've committed an act and it's led to the death. An omission, I did see, for example, come up in an exam question for AQA once. It caused some issues because people weren't fully aware that for whatever reason omissions can be. We dealt with in the previous video, actus reus, how there is a duty of care arising, and your failure to fulfill it, by breaching it, you are guilty. So it could be, for instance, the case of Gibbons and Proctor. Gibbons and Proctor, if you remember, the mistress and the father of the 7-year-old girl neglected her and she starved to death. So that conceivably could be, the actus reus of murder fulfilled through an omission. The only other exam question I was trying to think of, I think it's a long time ago now, so forgive me, I don't remember the year, but you possibly find it. It was where there was an altercation, I think it was in a pub or something like that, and the defendant chased a person down by I think it was a sort of narrow pathway and a sort of beside a sort of canal or riverway, and the person fell in, and they got sort of, as they were trying to get out of the river, got stuck or wedged between the boat and the bank, and I think the person then watched them struggle and then sort of walked away. And so that was arguably murder through an omission, the actus reus. We didn't mention it in the previous video, but you may know the case that came after Woolin, which confirmed one point of law as to, oblique intent and the foresight of consequences test being virtually certain. But it, I think, confirmed the point that the jury can, if they fulfill that test, if they feel the defendant has, find the intent. They can choose to find the intent, they don't have to. And that case was Matthews and Elaine. I think it was about 2003. And the point is, there's a bit of a link here maybe, and this is where I think it was the defendants threw this this victim over a bridge into the river below, knowing full well that the victim couldn't swim, and watched him struggle, sort of doggy paddle as best he could towards the riverbank. They walked off without seeing him successfully reach the other side, and of course he didn't unfortunately make it, and he drowned. And so the whole argument there is, you could argue certainly that by throwing him into the river, that was the act itself. Certainly you could also argue, couldn't you, the omission was the creation of a dangerous chain of events that they then failed to deal with. So there's ways and means. So going back to that AQA question, when that victim, I think it was in the riverbank struggling to get out, and the defendant walks away, that's the omission. That's the omission, because they've created a dangerous chain of events. So an omission is a failure to act, but where there is a legal duty to do so, it has to be recognised in law, either by common law or statute. So all of that stuff we've done before is relevant here. Now, murder is a result crime, which means that obviously the result is, in this instance, the victim's death, or victim's death. The prosecution have to prove causation. So everything we did in the previous video in relation to factual cause and legal cause is relevant here and has to be proven. Now, in most instances, it might seem obvious and clear, or it might be that the examiner has put in a problem scenario possible intervening act, or there might be an issue of thin skull rule. Maybe the victim has an underlying health condition, for example, that means that their injury, well, in this case, their death was more likely. So you would be expected to identify that and pick that up. I think it's always worth dealing with causation just briefly in a murder exam question, even if it seems straightforward, as it is one of the required elements. So when might a killing not be unlawful, I would ask my class. Can you give an example? And I think the one that generally I seem to get would be an issue of self-defense. So that links, doesn't it, to a future substantive topic here, which is general defences. In other words, necessity defences. Again, without going into too much detail, because for that defence to succeed, there are, broadly speaking, two tests. Was the use of force necessary? Was the use sort of reasonable and proportionate to the threat, not excessive? So it could be that if there is somebody like an intruder in your home, I think the law's tried through statute to balance it out, so it's perhaps more favourable to homeowners now and such people. But if you had an intruder, excuse me, and they were armed, and there was a struggle you had with them, and let's say they were armed with they had a knife or something, and you ended up through the struggle stabbing them, and they ultimately died, then feasibly you're right. There would be a defence I think a jury would accept with the evidence, and it would be complete acquittal. You would walk free. So a killing might not be unlawful there. And of course the other instances, it mentioned King's Peace, which I think I do come to in a moment, but in time of war, if you were to kill, like a soldier killing an enemy combatant, that would not be murder in that situation. So the main issue probably for murder to focus on is this reasonable creature in being part, which simply means, in ordinary English language, a human being. It's just the language obviously uses from a very old case, 17th century. And you can see there I've got a picture of a sort of baby in the womb. Now the law says that a fetus, a developing baby in the mother's womb, is not considered a reasonable creature in being. Now, why is that? It's a position the law takes. You may or may not agree with it. But according to the case of Attorney General's reference, number 3 of 1994, a child to be considered a reasonable creature in being, in other words, a human being in the eyes of the law, has to have, and this is a direct quote from the case, an existence independent of the mother. Now, when is it likely to have this existence? The law isn't entirely clear in some respects, but we would say certainly the child has to have been born. Now, does that mean, and this is the bit I mean, is it completely clear? Does it mean the child has to have taken its first breath? Probably, yeah. Does it mean the umbilical cord has to be cut? Again, probably not. So I think it's the child has to be capable of being born and have taken its first breath. Seems to be an existence independent of the mother. Now, yeah, I obviously asked my class, do you agree with the law that a fetus is not a human being? And people, obviously have some strong feeling one way or the other. Now, one thing to point out in a problem scenario, if you're presenting the exam, if the defendant, and this is what actually happened in the Attorney General's case I mentioned, if the defendant injures the mother, she gives birth prematurely, or, in other words, to an injured child who later dies as a result of that injury, okay, the defendant will be liable for the child's death because the child has been born. It was capable of an existence independent of the mother, but we can clearly trace the issue of causation, that the injury, that it was sustained while in the womb was due to the defendant's actions. However, it was also discussed in this case, and it was Lord Mustill who I think gave part of the judgment here. Transferred malice. So think of it this way: if there is a defendant who stabs a pregnant woman, we know that he or she, they are going to be liable for the injury to the mother. Now that could be attempted murder, GBH, whatever. But the law wasn't prepared to accept the rule of transferred malice, that mens rea rule, transferring to an unborn sort of child. And they said there the transferee, put it that way, had to be in existence at the time. So no, they weren't prepared to stretch the transferred malice rule that far, and we're only going to deal with situations where where the child is born, becoming therefore in the eyes of the law a human being, a reasonable creature, would then if that child were injured, would that then apply for liability to the defendant? So something to look out for anyway. Not on the exam board syllabus for AQA. I'm not aware of it being on there for OCR, but I thought it was an interesting story to raise. So the picture there of the defendant, if you Google this law, you'll find other examples too. Now, Dusan Bako, 18 at the time, repeatedly punched his 16-year-old pregnant girlfriend in the stomach, resulting in her losing the baby. Now, we already know that, as we've just discussed, it can't be murder in dealing with an unborn child because of the Attorney General's reference case number 3 of 1994. But there is this little-known law, I think dating back from 1929, called child destruction, and in this instance the charge was dropped for Dusan Bako, and he was convicted instead of causing grievous bodily harm, or if you will, serious harm, on his girlfriend. Now, why is that? Because if I put on the right hand side, this does carry a life sentence, this law. It's seen as a rather outdated law. It was more or less, created to deal with backstreet abortions, as was the case when abortion was illegal in this country, in the UK. But since statute, David Steele MP, in fact, I think it was a private member's bill, brought forward the Abortion Act 1967 with the support of the government, it's now rather outdated, and it's actually for the prosecution a hard offence to actually prove, because when we get to it, whereas with murder the mens rea is, in plain English, an intent to kill or cause serious harm, GBH. Here the prosecution have to prove, well, firstly the child was capable of being born, but secondly that the defendant, in this instance Dusan Bako, intended to kill the child, not just harm it but to kill it. And that is incredibly difficult to prove with evidence, because of course Dusan Bako could simply say, well, look, yes, I intended to seriously harm my girlfriend, but that wasn't anything to do with the child. And you could say, well, hang on a minute, you repeatedly punched her in the stomach, but again, does it show that he specifically intended to kill the child, or was he just again trying to harm the girlfriend? It's very, very difficult. Similar, in fact, to the offence of attempted murder, another substantive topic we deal with later, more broadly as attempts or inchoate offences, as it's called, because for attempted murder, the prosecution have to prove the mens rea of the defendant having, the intent to kill. And that's it. So for murder, it's intent to kill or cause serious harm, but for attempted murder, much like here with child destruction, it's an intent to kill, and that is a higher threshold, a higher line with evidence to prove. So often this is why these sort of offences can't always be proven. And I've got the link there to the actual news story if you want to check it out. Also, in terms of what is, or rather what isn't, a reasonable creature and being for murder, for the actus reus, in other words, not a human being capable of being killed, is a person who is legally brain dead but being kept alive by a life support machine. So because they are brain dead, no electrical activity in the brain, they are, in other words, no longer living, as no longer a person, legally speaking. And I say, just as a link to the previous topic, do you remember the ratio decidendi, the legal reason for the decision in the case of Malsharek in relation to brain-dead patients and doctors? It was a causation case. And you may well remember that if a doctor were to switch off the life support machine of somebody who was brain-dead, having, of course, followed the usual protocol and tests and such, then that is, not breaking the chain of causation. The defendant will still be liable if they were in fact the ones that, injured the victim and put them there in the first place. It will not be the fault of the doctor. Why would the law want to prosecute, doctors who are simply trying to look out for the best interests of their patients? And so, yeah, that's something just to be mindful of. And what I would say is that in an exam scenario, problem scenario, most times for murder questions, I'm thinking 30 marks questions here, it won't perhaps in the scenario mention an unborn child, or it won't mention a brain dead person. It will just be clearly a human being, by name. And therefore you don't want to waste your time writing about the law about either points, because really, you're under pressure as it is, and you should only write what is relevant to the scenario you're presented with. And so it's a very different, isn't it, to GCSE, where you would just write down everything perhaps that you know about murder or not. What you're trying to do at A-level certainly is you've got a toolkit, all this legal knowledge, and you're trying to pick out the relevant bits and only sort of analyse and comment on those. So yeah, but don't not revise this, because as I said, recent times they have, for example, slipped in an unborn child into a problem scenario, and what would be along with someone else who's been killed, and it was a case of, well, is it murder of this person and the unborn child? And don't forget the Attorney General's reference case, number 3 of 94. We mentioned this before, but the unlawful killing, of course, used to be Queen's Peace. Now in the United Kingdom, the King's Peace, just as I said earlier, means killing of an enemy in wartime, if you're a soldier, would not be deemed murder. So now we're up to the mens rea for murder, and the mens rea for murder is this Latin phrase, malice aforethought, express or implied. Now, with all things, do try and get the spelling as correct if you can. Certainly some cases can be challenging, but as I say, I think to my knowledge, for AQA anyway, I don't believe there's any marks for spelling per se, but it is how you effectively communicate and so forth. So yeah, do try and get it right. There aren't too many Latin phrases, thankfully. So you would in the exam write the mens rea for murder once you've done the actus reus and causation. The mens rea for murder is malice aforethought, express or implied, and then as part of your analysis, your AO3 marks, you would then say, express means and implied means. And in this instance, we're saying express means an intent to kill, and implied means an intent to cause serious harm, or GBH, grievous bodily harm. That was illustrated in the case of Vickers. So if I remember correctly with this case, you had somebody who was breaking into, I believe, a confectionery shop, a sweet shop, and went into the cellar and was disturbed by the occupant of the house, which I think was an elderly lady, and the defendant then assaulted her and kicked her in the head a few times and went away, and unfortunately the victim later passed away due to those injuries, and a murder charge still stood. We have the death, the unlawful killing of a reasonable creature, that was obviously the elderly lady, and then for the mens rea we have an intent to cause serious harm at the very least, and causation issues there aren't any, because that was he was a significant cause and so forth. So some scenarios to ask: is the offence of murder present? You may want to just pause the video to give you a chance to read these and have a look. But we have firstly, Dean is a loan shark who is owed money by Cheng. Unable to pay, Dean stabs Cheng in the leg with a knife and tells him he'll have to pay up in 3 days or worse will follow. Now, unknown to Dean, Cheng is a haemophiliac. I should say in the exam, I don't think they probably necessarily use that term, but I did. It means essentially your blood doesn't clot like a normal person's. You're more likely to bleed out. So unknown to Dean, Cheng is a haemophiliac, and he later collapses and bleeds to death. Is Dean liable for Cheng's murder? So everything we've done so far on this and causation would apply. So an answer for this is, look first of all, is the actus reus of murder there? And we're looking for that unlawful killing of a reasonable creature. Well, look, we've got Cheng. He, for all intents and purposes, it doesn't tell us he's a fetus or a brain dead person. He's clearly a human being. And it says he Dean stabs him and he dies. So that is the actus reus fulfilled. What about causation? Can we say confidently that Dean has caused Cheng's death through that actus reus? And you'll remember the factual and legal cause must be met. Factual is, but for Dean's actions would Cheng have died anyway, using the case of perhaps Hughes or Paget to illustrate. And I think it's clear here, isn't it, factually speaking, that Dean, is in fact the cause of Cheng's death. Now, if we go on to legal causation, because we need both, should we say that Dean is, would the law say that Dean is legally to blame, at fault? And what we say here is, has he made a more than minimal contribution to, Cheng's death by stabbing him. That's the Kimsey case we used to illustrate, and the answer would be yes. In fact, it's a significant cause of Cheng's death, isn't it? The stab wound. If you want to go drill down into it even more, remember that Smith case. What is the operating cause of death? Well, the operating cause of death is the stab wound. But you'll notice the mention of haemophilia. It's an underlying health condition, so you should have spotted the thin skull rule, and we know that doesn't break the chain of causation. That's the Blau case with the Jehovah's Witness. Therefore, it looks like we've proved causation. There are no intervening acts here, nothing there. And then that leaves us with the mens rea for murder. Malice aforethought, express intent to kill or implied intent to cause serious harm. Now, given that he stabbed him in the leg, that would suggest, I would say, not an intent to kill, because he was owed money, and if he killed him, he could never get his money back. So it demonstrates the intent to cause serious harm. So that would be the Vickers case that we spoke earlier of, with the elderly woman who was viciously assaulted in her cellar by a I think it was a burglar or a thief. So all said and done, there we are. Now, second one, Ethel, a rich author, believes that Matthew had her granddaughter killed when they were in a relationship. She lures Matthew to her office, where he believes she's signing a new will in his favour. When she asks him to place it into the walk-in safe, she locks the safe door behind him. He dies after running out of oxygen a few hours later. Is Ethel liable for Matthew's murder? So same as before, is the actus reus of murder there? We're looking for a reasonable creature and being, a human being. It says Matthew. It does not say anything, again, that he's a fetus or an unborn child or a brain dead person, whatever. So we're just going to simply say the actus reus is fulfilled by Ethel when she locks him in the safe and he dies due to lack of oxygen hours later. Causation, same thing. So factual cause, but for the actions of Ethel, would Matthew have died anyway? Hughes or Paget case. The answer is no. He wouldn't have died anyway, so clearly she is in fact the cause of death there. But we need legal causation. Has she made a more than minimal contribution by her actions of locking him into that safe? That's the Kimsey case. Well, once again, I think we can safely say it's the significant cause of his death, because he, runs out of oxygen. Do we see any intervening acts as a possibility, or any of the other things we've previously discussed? No. That leaves us with causation being established. What about mens rea? We know it's malice aforethought, express intent to kill or implied intent to cause serious harm. And I think, given that she lured Matthew, that's the key word, she lures Matthew because she believed that he had killed her granddaughter. I know that we say that motive is not the same as mens rea, because mens rea, remember, for murder, it's intent to kill or cause serious harm. But I think that helps give context here to say, I think she intends to kill him, basically. Because if you put someone in a huge safe or vault, a walk-in, kind of safe or vault, and you shut it behind, it's airtight, you're going to run out of oxygen and die. So, yeah, I think that's murder. And then we've got Jeffrey stabs his estranged wife Susan 9 times. She is admitted to hospital, but due to the wrong drug being administered, she suffers a cardiac arrest. The medical team managed to restart her heart, but she suffers brain death. Now the doctors turn off her life support machine. So again, in a typical sort of question for this, unless of course, as I say, it's 10 marks. For AQA, a 10 marks question can narrow it down onto one specific aspect potentially. Same thing, actus reus, yes, we've got Jeffrey stabs Susan and she later dies, so that's fulfilled. Causation, this is where this one is different, because what we have here is the medical aspect, the treatment. So factually, I think we can say the test is met. Is the legal test met for causation by Jeffrey? Has he made a more than minimal contribution? Yes, he has. But no, she, when the medical staff are treating her, her heart stops, she suffers brain death, and then she dies when the life support machine's turned off. I think this is a case of, similarly to Smith, the two soldiers that we talked about earlier, the fighting in the barracks. One got stabbed in the lung, the victim, then was given poor treatment, but the poor treatment wasn't deemed to break the chain of causation. The operating cause of death was the stab wound. And I think here, we also know the case of Malsharek we mentioned earlier. A doctor turning off a life support machine when the patient is brain dead, in other words, no longer a reasonable creature and being, no longer a human being, would not break the chain of causation. So causation, I think, here is established for Jeffrey, and the mens rea, well, he stabbed her 9 times. I should say, sorry, estranged means, separated, no longer together. So he stabbed her 9 times. I think the volume, the amount of times he stabbed her, indicates an intent to kill. And so therefore, we can safely say murder. I've put in there, just having a look, sorry, just check. Drug being stuff. Oh, beg your pardon, sorry. Silly me. I should have seen that. I'll reverse one part of what I said. I think you're ahead of me on this. It would, in fact, be a break in the chain causation, arguably so, because what I didn't see there, she was given the wrong drug. That was the key bit. Sorry, I read the bit ahead. Always read the question and the scenario. So, because she was given the wrong drug, there is a possible argument that this is similar to the Jordan case, and therefore it's down to the medical treatment being palpably bad, and therefore she dies as a result of something that is so independent of what Jeffrey has done. Okay, so it's the drug that causes the cardiac arrest. The operating cause of death is due to that drug. So I'm just going to correct that. That's why, if I flip it again, we have the actus reus, we have the mens rea, but the causation part, we do have seemingly an intervening act by a third party. So just want to be clear. 3 more. A hitman, Agent 48, is hired by a woman who does not want a divorce, but instead to kill her husband Ian and inherit his wealth. Unfortunately, the hitman is incompetent, and when he is about to shoot Ian, misses and kills an innocent passerby named Phil by mistake. Is the hitman liable for the murder of Phil? So, again, you can take a little bit longer with these now if you like, but is the actus reus present? Well, yes, it is, because of course Phil is a human being, a reasonable creature. Are there any causation issues here? No, I don't think factual legally there would be. And mens rea then, intent to kill or cause serious harm. Well, he has, as a hitman, I would assume, an intent to kill, which is express malice aforethought. But just by the fact that he misses and hits an unintended victim, you should know or remember by now that won't prevent liability. We have a rule called transferred malice, and in this case, his malice, his intent to kill Ian, has transferred to Phil, the another victim, and he will be liable. And I think we used the Latimer case, didn't we, for transferred malice, which is the defendant having an argument or a fight in a pub, very old case. Takes off his belt, tries to launch it at his victim. It hits the victim, but also bounces off of that victim and hits a woman, another victim, the unintended victim, in the face. And that's really what we're seeing here. Matt has an argument with his partner Claire, who is pregnant. As he is unhappy about the pregnancy, he pushes her down a flight of stairs in their home with the intention of ending the pregnancy, which it does. Is Matt liable for the murder of Claire's unborn child? Now, you should be ahead of me on this one. The actus reus then, we need a reasonable creature in being, and we do not have one in the eyes of the law in the UK, because of course an unborn child is not deemed a reasonable creature. So the Attorney General's reference number 3 of 1994 is the case you want to discuss, and essentially that is the end of the argument really there. No need to talk about causation or mens rea. That certainly resolves it. Now, Selina throws a large stone into a river to see how much of a splash it will make. Jake is swimming in the river and is hit on the head by the stone and dies as a result. Is Selina liable for the murder of Jake? Starting again, do we have the actus reus there for murder? Yes, we do. Jake's a human being, a reasonable creature. Causation, are there any issues there with causation? Seemingly not, factually and legally. But I think where this one is going to, be challenged, and happily for Selina, is that she doesn't appear to possess, does she, the mens rea for murder? Malice aforethought, express intent to kill, or implied intent to cause serious harm. And I think I've put here, if in doubt, in that situation, you could consider, couldn't you, oblique intent. Clearly not her desire to have killed Jake. Do we think that the defendant foresaw her consequence of, throwing that stone and killing Jake as a virtual certainty? And I think, just to pop back again, from facts we have here, the answer is no. Now, whether it could possibly be involuntary manslaughter, again, is not something I think we'll go into now. I mean, it's worth mentioning about the exam that typically, from what I can see in AQA anyway, is the question. I always say read the question first in a problem scenario, and then read the scenario, and then go back to the question. But it should usually say the word murder. So, consider the criminal, or whatever it is, consider the criminal liability of, Selina for the murder of. And so you're focusing on murder. If the question were to say for the death, consider the criminal liability of Selina for the death of, then usually that's a pretty good clue that you're in the realms of involuntary manslaughter. You remember that being unlawful act manslaughter, otherwise known as constructive, or gross negligence, rather than murder. So there's this absence, isn't there, of mens rea for murder. So yeah, anyway, Selina, no. Okay, just a few more sort of puzzles or riddles here. I can't claim to have written them myself. I found them online, but if you like these, then by all means you can pause the video and read through them now. And I am just going to flag up the answers. So we have, how can the murderer shoot him in the stomach if he came up behind the man? Secondly, I always think this second one, it sounds better when you say it. When it's written, it's probably a bit too easy. But clearly, the room with the lions, because let's face it, they'd all be dead at that point. And then the last one we've got, he never actually asked the cop where the scene of the crime was. So how did they know? So they knew that he had murdered his wife. They clearly, he turned up and knew where to go, and only the murderer would have known that. Okay, moving on. Should you go to prison if you kill? Are there any circumstances when this shouldn't happen? Now, this is really a link into what's going to be voluntary manslaughter. It's linked specifically to murder, and we call these two defences, diminished responsibility and loss of control, we call them special and partial defences to murder. They're special because they apply only to murder, these two defences, no other offence. So, be careful, don't raise these for anything else. And they are partial because if successful, the defendant's charge of murder will be reduced to voluntary manslaughter. It's voluntary because they have still killed the victim. They've kind of they chose to do it, if you will. But what we're saying with these defenses is there was a justifiable, in the eyes of the law, reason as to why they did it, and the law is prepared to accept that the person, therefore the defendant, is not at the same level of blame or fault as somebody who directly intends, for example, to kill someone because they want them dead. So we're going to deal with diminished responsibility first, and this topic becomes more challenging because it is an example of a statutory defence. So this has been laid out by Parliament, but common law, the case law, helps then to further develop the law. So for the exam, you will need to know both. So we need to know, for example, here, that Section 2 of the Homicide Act 1957 is where we can find this defence, but it has since been amended, in other words, altered, by Section 52 of the Coroners and Justice Act 2009. We might just talk shortly about a couple of those changes. I think really they were just to clarify the law, nothing as significant certainly as loss of control, where that's a whole different ball game. So with that in mind, we're going to move forward. So the defence of diminished responsibility you can see on your screen now in the video, and this is one of the challenges of these topics, you're going to need to memorise the 4 points. Okay, now, so it says here, a person kills or is party to the killing, and is not to be convicted of murder if they were suffering from, all right, here we go, an abnormality of mental functioning. That's the first part you can see. So we're looking at their things like, how has their mental functioning been affected? Are they suffering from perhaps delusions, as some medical illnesses can be? Were they otherwise affected mentally by not being able to understand what they're doing, whatever? So that's the first one. Okay. The second one is it has to be due to a recognised medical condition, and there has to be medical evidence presented to court by the defendant for this to succeed. I think I worth saying, I don't know if I say it later, but the standard of proof in a criminal case, how good must the evidence be for the court, or indeed if it's in the Crown Court, like murder would be, the jury, to reach a verdict? And we know it's beyond reasonable doubt, so it's quite a high threshold, isn't it? For a good reason, if you're going to convict someone of murder and mandatory life sentence and send them to prison. But if this defence is raised by the defence, as you would expect, then the standard of proof reverses, and it's on the balance of probabilities. So the defendant and the defence team only have to prove this defence on the balance of probabilities. It's a lot lower than the criminal standard I mentioned earlier of beyond reasonable doubt. It's essentially just almost like 51%, more than the other side in terms of how persuasive with the evidence you've been. But it must arise from a recognised medical condition. Now, the exam question in the scenario could specifically mention it. If it said, for instance, schizophrenia, then we mentioned earlier, hallucinations, delusions, that's something that could be present with that, and that would affect the mental functioning, so that's clear. But it could also be a whole range of other medical conditions. So we're going to see shortly, it could be things like, severe depression, PTSD, post-traumatic stress disorder, whatever. All right. So if the exam question doesn't say it, but mentions, hallucinations or otherwise, as I mentioned, then you might want to just make a comment in your analysis that it's likely to be schizophrenia. If they have something like feelings of despair, that might be a good indicator that one could conclude with medical evidence that it is depression, and so on. So once you've got that, we've got the fact that it must substantially impair the defendant's ability to do at least one of the following three things. Now, if all three things are present, great for the defendant, but at least one will be enough for this defence to work with that medical evidence. So look out in an exam scenario whether it's one or more, and you would be expected to comment and analyse it. And that is substantially impaired their ability to understand the nature of their conduct. So basically, the mental illness, if you will, means that they don't know what they're doing. Now, if it was a schizophrenic and somebody was suffering from delusions, perhaps they think a person is not who they are, then that would clearly meet that part. Or it could be their inability to form a rational judgment, and to think rationally means, in other words, to think logically like a normal human being. Perhaps that has been substantially impaired. Again, if we take the example of, as I said, delusions with a schizophrenic, then they're not thinking rationally, are they? And then the last one could also be, or exercise self-control. Could it be some sort of medical condition there that means they have that inability? They're more likely to explode. Now, don't confuse this with loss of control defence, although it mentions self-control. And then the last point, number 4. Actually, number 4 is one of the changes that Section 52 of the Coercion and Justice Act made. And that is, they wanted to establish clearly in the minds of the jury that the mental illness, if you will, and what was substantially impaired, there's a causal link between that and why the defendant is killed. So that's really the last point. It provides that explanation. Some students tend to forget point 4. I'm not sure why, so just make sure you remember it's 4 things you need to outline in your answer before you make comment. So if we move on, and I think the key case here we want to talk about is Byrne. I use this case, or expect to have this case be the supporting point for the abnormality of mental functioning, that first bit. And here we had a sexual psychopath, irresistible urges to strangle young women, and I think this is a really useful ratio decidendi. I think for those students who want to do particularly well in the exam, it's worth remembering this quote. It came from the Court of Appeal in this case. And they said, an abnormality of mental functioning is a, quote, state of mind so different from that of an ordinary human being that the reasonable man or reasonable person would term it abnormal. So that really, nails down what abnormality means. Now, this case was 1960. I should have said earlier, but the first point of the defence used to read abnormality of mind. Then, with Section 52 in the Coercion and Justice Act, it was altered to mental functioning. I don't really see there is a great deal of difference, but perhaps it just clarifies once again to the jury, to the court, that it's, how they're functioning as a person that links to that substantial impairment. And then, of course, that added bit at the end about provides an explanation. So that's the case we use for abnormality of mental functioning. The case of Golds is something I think that needs to be put in with the third point. So we're skipping one a minute, I know. The issue of substantially impaired. So Golds 2016, very simply, defendant killed his partner, admitted the killing. The ratio decidendi, the law from this case is, as far as I understand it, it's a bit of a tricky case, Substantially means an impairment of some importance and not trivial. So they basically try to explain what substantial means. I'm going to add the following though. As far as I understand it, the judge who directs the jury in a Crown Court trial as to the law would not seek to give a direction on what substantial means. They would leave it to the jury. I think that's what the Golds case makes clear. They leave the meaning of the word substantial to the jury, takes its ordinary meaning. However, if the jury require or ask for, I should say, some sort of explanation of what substantial means, I think that's essentially what this case has tried to give us. So that case of Golds is used for the third part of the defence when you're explaining substantially impaired. Gittins, not a very pleasant case. We've got here the defendant attacks and kills his wife with a hammer and then rapes and kills his stepdaughter, I think it was. And the law from this case is it wasn't successful for the defendant here. I think he'd been intoxicated, more on that in a minute, and was suffering from severe depression. But certainly the court weren't willing to accept that the severe depression was, what was substantially impairing him at the time. So I should say now, we'll come to it later, the intoxication issue is entirely removed and separate unless it's a particular illness called alcohol dependency syndrome. But the court did accept in this case that with medical evidence, severe depression is a recognised medical condition and could form the basis of a successful diminished responsibility defence. But the court just weren't prepared to accept it in Gittins' case. And what's interesting actually is, and we're going to come to this again later, and I'll show you an example. Even if you present this defence and you have the medical evidence, the jury can choose to ignore it. So it doesn't mean you're necessarily going to win. We come to the case of Ahluwalia, and this case is going to come up again for the loss of control defence. But in relation to this, and this is actually a film still, this is from the film Provoked that they made. Essentially the facts very briefly. I mean, she was in an abusive relationship, marriage, with her husband, Deepak, I believe his name was. And a number of things had been done to her. I think she'd been, physically and emotionally abused. She'd been sexually assaulted. At one point she was pushed down the stairs whilst pregnant with one of his children. And there was about 10 or 11 years of marriage, I think it was, and it culminated in one night where there was a big argument. He threatened her with an iron that she'd been using at the time, and she was fearful for her life. She waited until he was asleep, and then she at night came up the stairs with a lit candle and some, I think it was petrol in a container, poured it over his feet, and then he set him alight. Now whether she did that on purpose or dropped the candle, we'll never know. She was originally convicted of his murder because she tried to use a defence other than diminished responsibility. We'll talk about that later, and didn't have any success. It was on appeal after I think 2 or 3 years she'd served in prison that she attempted to raise the defence of diminished responsibility. Now it is worth noting that generally speaking on appeal, I think appeal courts don't like to hear the defence of diminished responsibility being raised on appeal. I think they'd much rather it was dealt with at trial, the court of first instance. So it's really only if there's compelling evidence, or I suppose new evidence that suggests that the defendant, in this case Ahluwalia, was suffering from an abnormality of mental functioning, as we call it now at the time, that they'd be prepared to hear that appeal. And of course they did, and I think it was endogenous depression, or what is phrased now in the context of her situation as an abused spouse as battered person syndrome, or battered woman syndrome as it was known then. So this case is a useful case for arising from a medical condition. That second point of the defence we discussed. I think I would prefer students to put Gittins there, but if the problem scenario you're presented with has someone that, an abused sort of person, domestic violence, you may certainly want to raise this, and specifically this syndrome. So as I mentioned, you can read the story provoked in her own words of Karanjit Ahluwalia. You can get that online, quite cheap, and there was a film made in 2006 which is worth watching as well, although obviously being a drama there are parts of it that have been altered and so forth, and characters created for that story. Is there a defence of diminished responsibility where intoxication is involved? Now, we mentioned this earlier, and my response was no. Intoxication is irrelevant. It's a removed part of the defence, unless we specifically see alcohol dependency syndrome. So if we move forward, look at some cases. We've got Deichmann, and in this case, the defendant drunk, suffering from a depressive grief disorder. So as you can see there, with medical evidence, that's kind of the recognised medical condition that was affecting his mental functioning. His inability to think rationally, his inability to sort of exercise self-control, all of those were substantially impaired. Anyway, he ended up killing the victim because I think there was an argument where the watch fell to the floor, got broken. He turned on the victim, who he, in his mind, accused of breaking the watch, and the watch was given to him by, as I say, his late aunt, who he'd recently lost, was still very upset about, and given his depressive grief disorder, he attacked the victim and I think kicked him to death. So the law from this case, the ratio is, where the defendant is intoxicated, diminished responsibility as a defence to murder can still succeed if there is a pre-existing abnormality of mental functioning. So in an exam scenario, if it says intoxication, right, yes, there's the defence of intoxication, that general defence, more on that later. But in terms of diminished responsibility, just look for a possible recognised medical condition you can hang the defence on, and make comment that otherwise the intoxication is irrelevant. Case of Wood, we've got here defendant, an alcoholic and drunk at the time, killed the victim when he woke up to find that the victim was making unwanted sexual advances towards him. Ratio then, this is the case for alcohol dependency syndrome. This is the case we want to raise if we feel this is relevant. So again, I'm just trying to think problem scenarios and such. If the scenario suggests intoxication, then I think the examiner's wanting you to discuss what we've just talked about, how intoxication is not relevant. Even being an alcoholic wouldn't be enough. If there's indications that the defendant has any degree of control over their drinking when they start and stop, all of that won't be relevant. But if they are so dependent on alcohol as to be, that, or indeed, I don't know if the problem scenario would actually explicitly say alcohol dependency syndrome, well, you should talk about it as, the law says this, however, if it were that with medical evidence, the outcome would be this. So, bit of analysis and evaluation, assessment objective 3 for this defence, remembering, of course, that we said before the 15 marks question is certainly analytical and evaluative. Any problem scenarios also have a degree of AO3 in there as well. And I said about how the jury could, even with medical evidence, disregard the defence of diminished responsibility. And we've seen that in a very famous case, Peter Sutcliffe, the Yorkshire Ripper, who I think, I don't know any more details here, but memory serves, he had his killing spree. He started, I think, as a grave digger at one point, and he began to believe that God was speaking to him, and God, he alleged, was telling him to kill prostitutes, to go on this divine mission to kill prostitutes. Now, it's worth saying, of course, that not all of Peter Sutcliffe's victims, female, were prostitutes, but that is the defence he tried to put forward, and he was diagnosed at trial with schizophrenia, but because of the uproar all these killings had been that it had caused due to this serial killer, I think essentially the jury felt he should be punished, and therefore they treated him as a murderer, and he was convicted of murder, even though, as I say, he was a schizophrenic. So you've got an interesting argument here of, on principle, is it fair to convict someone who has a recognised medical condition that provides that explanation for why they kill, for that to be denied when perhaps they're not at the same level of fault of somebody that didn't have an abnormality of mental functioning? So is it fair to convict someone and treat them the same? But equally, I think it's fair to say that through the case and how he committed the murders and the attempted murders, it was clear as well that he knew what he was doing. So it's an interesting point to discuss. The second one is voluntary intoxication is not relevant. That is because the fault lies with the defendant. If they choose to drink or take drugs, that's a public policy reason. We'll talk about the defence of intoxication in a later video, a general defence. It's not really, strictly speaking, a defence, because whereas with other general defences it leads to complete acquittal, the law has a balancing act. We don't want the law to say, you were drinking, you have a defence. For example, what we're talking about now, murder. So the law is quite strict and will allow only alcohol dependency syndrome, not alcoholism or just heavy drinking or whatever. And then linked to something else, section 52 of the Coroners and Justice Act, yes, has that bit added in I mentioned about providing an explanation for why the defendant killed or was a party to the killing. And that was one of the changes made by that recent statute, so that there was a clear causal link between the abnormality from that recognised condition that substantially impaired them, and that has led to them killing. And I think that's one thing that the statute tried to make clearer in the minds of the jury. So yeah, in the news, I'm not going to dwell on this, but that actually was what I was referring to with Peter Sutcliffe, and the fact that the jury disregarded the fact he was a schizophrenic. Would you have done the same? Interesting question. It's worth looking up that case to find out a bit more detail, perhaps. So, will the defence of diminished responsibility be successful? Here, let's have a look. So we've got Anea is in an abused and controlling relationship with her husband, who regularly beats her. She is deeply depressed. One evening, after a violent confrontation, Anea waits until her husband is asleep before hitting him over the head with an ashtray, killing him. Can she, Anea, use the defence? Now, at this point, you might want your book open or your notes open. You need the defence outlined in front of you, those 4 points again that I had on the previous slide. So what you're asking here, for example, is there an abnormality of mental functioning? That's that Byrne case, remember, the sexual psychopath. State of mind so different from the ordinary human being that a reasonable person would deem it, abnormal. So if we start with that, mental functioning affected, not a lot to go on perhaps, but we've got there that she is deeply depressed, so her mental functioning is certainly affected in that she is depressed. The recognised medical condition, and I would be using the Gittins case here. Remember, that was for severe depression. The man who attacked his wife and killed his wife with a hammer, and then subsequently his stepdaughter. The Gittins case, well, we can see the word deeply depressed here, the words, so there's a link there. But given it's an abusive and controlling relationship, you may want to also raise, and I think I would, the Ahluwalia case and battered person syndrome. So though normally it's one case per element, I think in this instance, because of that, there's an opportunity to expand our answer for that bit. Now, having done the first two bits, is there, what's been substantially impaired? And remember, looking at your notes, there are three things. We want at least one. Substantially impair the ability to understand the nature of their conduct, so they don't know what they're doing, in other words. It could be to form a rational judgment, they were unable to do that, or unable to exercise self-control. Now, if we look here, on face value, I would say the indications are she knows what she's doing, perhaps, because she does wait until her husband is asleep. It's very similar, isn't it, to the Ahluwalia case. Perhaps it would be a safer bet to argue that she's unable to think rationally, or indeed self-control could be an argument. And then lastly, and that's the Gold's case, the Gold's case for substantial. Leave that word to the jury, takes its common, ordinary meaning, but if you are going to direct the jury, if they ask for it, it's got to be something, I suppose, that is, significant. And does it provide a reason for why she kills? I think it does, so we're going for yes. Second one, Bruce believes the government are monitoring all of his phone calls as he has evidence that extraterrestrial life exists. His boss at work is an alien. While waiting at a train station, he sees a man in a black suit next to him. Believing he is being followed, Bruce pushes the man into the path of the oncoming train and kills him. Can Bruce use the defense of diminished responsibility? So again, look at your notes, those 4 points, and do we have an abnormality of mental functioning? I think we can certainly say there is evidence here of paranoia. He thinks his phone calls are being, monitored. Perhaps he's being followed and whatnot. Possibly evidence as well of delusions. If we were to pin it to a recognised medical condition, we would say schizophrenia, perhaps. And does it substantially impair his ability to do anything? Well, I think we're looking at, does he know what he's doing? Perhaps there's an argument he doesn't know the nature of his conduct because he perceives here an alien rather than a person. I think certainly we can say it's safe ground that his ability to think rationally, to form a rational judgment, is substantially impaired. Exercise self-control, possibly that as well, but certainly the rationality part. And does it provide an explanation for the killing? I think it does. So we're going with yes. I've put the Byrne case there, but just remember, I think with the 4 points we're going through like a checklist for this defence. Byrne for the first one, Gittins for the second, and then we go Gold, and then there isn't in fact anything for the fourth one. Chow is suffering from schizophrenia and has stopped taking his medication. He begins to suffer from delusions that people are demons and kills his elderly neighbour. Can Chow use the defence of DR, diminished responsibility? Now, the abnormality of mental functioning here is the delusions. Useful that the scenario mentions it. The recognised mental condition is schizophrenia, clearly. What's been substantially impaired? Well, similarly, doesn't understand the nature of his conduct. He sees demons, not people, or the elderly neighbour. Cannot think rationally, and so forth. Possibly even exercise self-control. So you could say it's all three, but most certainly doesn't understand the nature of their conduct or think rationally, and I think it provides an explanation. So we've got yes for this one as well. Now we've got Jack is a sexual psychopath who strangles and kills young women. He argues in court that he suffers from irresistible urges, and should he be released, he will kill again. Can Jack use the defence of DR, diminished responsibility? It's a carbon copy, really, of the Byrne case, isn't it? So I think the abnormality is the irresistible urges. That's the mental functioning that's abnormal. The recognised medical condition is the fact of his psychopathy. He's a psychopath. Substantially impaired, well, I think clearly this one is the ability to exercise self-control. It's irresistible urges he can't control, and it provides the explanation. And I think clearly you would say in your answer how that relates directly to the Byrne case. And again, using that quote from the Court of Appeal in that case, a state of mind so different from an ordinary human being for a reasonable person to deem it abnormal. That's basically what we have here. George meets Sarah at a party, offers to drive her home. He makes sexual advances towards her and she slaps him. So he punches her in the throat and she dies. George suffers from frontal lobe damage and epilepsy. Can George use the defence of DR? Abnormality here, looking through, doesn't really give us a lot to go by, I think. But one would say, frontal lobe is sort of the centre for, I think, where your sort of emotions and so forth are, and your control. So maybe he's certainly more easily agitated or angered, shall we say. The abnormality, the recognised medical condition would be indeed frontal lobe damage and epilepsy. So both of those fit. Substantially impaired, I think probably to think rationally perhaps, but certainly to exercise self-control. Does it provide an explanation? Well, I think it does for the killing. So we are going yes for that. Jane has been married to Stuart for 15 years and now finds him increasingly annoying. Jane is going through the menopause. After arguing over some unpaid bills in the kitchen, Jane stabs Stuart in a fit of rage. Can Jane use the defence of diminished responsibility? Now, one thing to say with respect to the menopause, and I am by no means an expert on this, but it is sort of known as for women that go through it, and I think every woman certainly does go through it at some point in their life, some earlier than others. It's a change of life. It's their body is changing hormonally, and therefore the chemical change in the body, the hormonal change in the body, means that they are certainly affected. There are some who become more irritable, some more, certainly more inclined to be more emotional. And there can be extremes of this. So the abnormality of mental functioning here could very well be that sort of being more easily angered, or the emotional instability. The recognised medical condition would in fact be menopause, and obviously medical evidence needs to back this up. Jury then left to decide. What's substantially impaired? Well, I think the clear thing is the inability to think rationally, but most certainly the inability to exercise self-control. That's been substantially impaired, and I think it would provide an explanation for the killing here. Then we've got Jonathan is a binge drinker in a violent relationship with another habitual binge drinker. After a violent altercation with his partner, Jonathan kills him. He later claims he has no recollection of killing the victim. He admits that he can choose when to drink, but once he does, he cannot stop. Can Jonathan use the defence of diminished responsibility? Again, abnormality of mental functioning. We would say, again, not much to go by perhaps. No recollection, so his memory is affected. That certainly could be relevant. Perhaps he's more violent, more emotionally unstable. The recognised medical condition, well, this is the problem, isn't it? Because it mentions intoxication, and we know that intoxication is irrelevant unless it's alcohol dependency syndrome. Now, you would be expected to write that in your answer to this in the exam, but the key thing is he admits that he can choose when to drink. So the fact that he exhibits a degree of control means that he has no recognised medical condition for this defence, and therefore the defence will fail. And that's the case of Deichmann, I think, to use. If you used wood, that's fine, but I think Deichmann makes the point that intoxication is irrelevant. Graham suffers from severe depression since the death of his wife and child. While drunk and drinking in a bar, a man spills his drink over Graham by accident. Graham punches and then kicks the man to death. Can Graham use the defence of diminished responsibility? Carbon copy, isn't it, more or less, of the Deichmann case? So I'm simply going to say, in the Deichmann case, we heard, didn't we, that it was a severe, I think it was grief depressive disorder, if I got my words correct there. But we know depression from that case, and indeed Gittins can, with medical evidence, be enough. We ignore the intoxication, and what's been substantially impaired here, perhaps, is the ability to exercise self-control. Paula suffers from a head injury since early childhood, which causes her personality to change. While smoking cannabis, a door-to-door salesman knocks on her door. She picks up a knife, stabs and kills him. Can Paula use the defence of diminished responsibility? Now, intoxication, just to be mindful, can be through drink, drugs, or solvents, and in this case it's the first scenario to deal with drugs, and in this case the illegal drug of cannabis. So what do we know? We know that intoxication is irrelevant, so we move that aside for this defence. What are we left with? We're left with this head injury that causes her personality to change. That may well be enough. So the abnormality is changes to her personality. The recognised medical condition is the sort of head injury, or the brain damage or whatever she suffered, and what's been substantially impaired is her ability, presumably, to exercise self-control, perhaps even to think rationally, and that could provide an explanation for why she killed the salesman. And I'd use Deichmann just to make the point about intoxication again. We've got Jennifer is suffering from acute stress disorder since losing her job. In a heated argument with a friend while intoxicated, she strangles her friend to death. Can Jennifer use the defence? Very quickly now, abnormality, stress, anxiety, recognised medical condition, acute stress disorder. So we're not talking about simple day-to-day stress. We're talking about a recognised medical condition, severe distress, medical evidence needing to support. Is there anything substantially impaired? Well, she's in the middle of an argument. It could be the ability to exercise self-control, at the very least. The intoxication, though, is, like with Deichmann, again, irrelevant. So it looks like we've got an explanation for why she's killed the acute stress disorder. Aurelia is an alcoholic. She drinks every day, but chooses to stop in the evening when her husband Fayard returns home from work. Fayard tells her that he is leaving her, so she stabs and kills him. Can Aurelia use the defence of DR? Again, what do we know about intoxication, diminished responsibility? The Deichmann case says it is irrelevant, particularly so where, as we've described, the person has any control over their drinking. Alcoholism is not enough. Is there some sort of abnormality to hang this defence on otherwise? Doesn't appear to be, does it? So unless with medical evidence she can say she's actually suffering from ADS, alcohol dependency syndrome, I don't think she has a defence. And the Wood case is what we can use making that point. While intoxicated, Maria believes her partner Tina is cheating on her. This is in fact untrue. Consumed by jealous rage, Maria has an argument with Tina and strangles her to death. Can Maria use the defence of diminished responsibility? Intoxicated, right, so let's ignore that. Abnormality, well, it seems to focus on the jealousy part, doesn't it? She seemingly cannot think rationally. Now, jealousy, broadly speaking, you would say is not a recognised medical condition, but there is a possible condition I've read about called Othello syndrome. It's named after the Shakespeare play, and it's where somebody suffers from all-consuming feelings of jealousy that are far and beyond, so excessive of what a reasonable person like you or I would actually have. So, for instance, if somebody is so consumed with jealousy, even when it's clear by the evidence, by the facts, that there was nothing to be jealous of, so like this case here, there is a possible thing to exercise here for the defence, substantially impairing perhaps the ability to think rationally, to exercise self-control and so on. So I've put the word possibly, but that would be one to argue. Right, so at this point, for special defences to murder, that leaves us with loss of control, the last defence to murder. And what we need to know about this is that it's found under Section 54 of the Coroners and Justice Act 2009. Just as before, it's special and partial defence to murder. Special because it's only to murder. Partial because it will not reduce, it will not completely, eradicate fault. The defendant has killed someone, but it will reduce the sentence from mandatory life sentence to, if successful, a discretionary life sentence where the judge can have the choice as to whether, how many years you may serve in prison, or, whatever that might be. Now, it's worth noting you don't need to know too much about the old defence that was there, called provocation. So loss of control defence has replaced it, but the changes we will see in the loss of control defence are as a result. So it's nice to just contrast the two. And cases like that we've come across so far, the case of Ahluwalia, and you can see a picture there, this time of the actual real Karanji Ahluwalia and her husband Deepak, the victim. I think cases like this highlighted how the old defence of provocation didn't support victims of domestic abuse. So we remember the cases where she was an abused spouse many years, and one night after a confrontation she waited until he was asleep, and then she crept up the stairs, poured petrol over his feet and set him alight with the candle, and he died. And she was subsequently charged with murder. Now at trial, she tried to raise this defence of provocation, but because the old defence said, if you lose control, it must be a sudden loss of control. Because she waited until he was asleep, that meant the defence would fail, and it certainly gave more credence or evidence that this was murder, that she intended to kill him, that she waited. It was premeditated. So, as you can see here, the defence of provocation wasn't successful for her, and in the end, as we described, it took a further appeal on the grounds of diminished responsibility and new evidence for her to claim battered woman syndrome and be released from prison. So the old defence fails to recognise that a loss of control can be cumulative or a slow burn. It builds up over time, and certainly she had experienced years of abuse, and what we're essentially saying is after that final confrontation prior to him going to sleep that night, it built up, and she just sort of snapped inside, and she lost it. But that old defence of provocation didn't allow for anything other than the loss of control being sudden. Now, who is more likely to lose control in the moment, male or female? And I think most of us would certainly agree that it would be males, be that for biological reasons such as testosterone or otherwise. So immediately we can see that this old defence of provocation not only failed to serve people who lose control over a longer period of time, but it's certainly got some sort of male bias, or it favours males, that defence, more than female. So it meant that Ahluwalia only succeeded on appeal with a defence of diminished responsibility, effectively arguing, as I think some put it, that she was insane. And so clearly, and there's an interesting article there you might want to look at to read her story, clearly there was a need for the law to redress this, and therefore provocation defence to murder gets replaced by loss of control, which is what we're talking about for this exam. So I've put some of the points there for analysis and evaluation. The old defence, the sudden point we just talked about, that didn't really help. That's got rid of. Doesn't favour slow burn cases. The old defence of provocation had a gender bias favouring men. Certainly, women who were fearful of their partners, as Ahluwalia was, and the serious violence he might commit on her, weren't really benefiting from that defence or given a reason. And the last point here is, we already know that there's a gender bias for men, but the old defence of provocation used to allow sexual infidelity as a reason for the killing, and therefore a defence to murder. Sexual infidelity is, in other words, the belief that your partner has cheated. So either you have that belief, or you catch your partner in the act of having an affair with somebody, and therefore, if you're a man, you're more likely to lose control, and you're going to kill either the partner or the person that they're with, and therefore you would have a defence. And plainly, and certainly by modern standards today in society, that is wrong. So the new defence tries to redress that balance, loss of control, by removing sexual infidelity as a reason, a justifiable reason by itself to kill and have a defence to murder. And that is because, women are no longer seen as property. And it's a very sort of patriarchal, male-dominated society, the law. And clearly there's no good reason to be accepted that you kill because your partner is having an affair. So Section 54 of the Coroners and Justice Act 2009 sets out, broadly speaking, 3 elements, and once again you're going to need to know these 3 elements and learn the wording as closely as you can. So firstly, the defendant must suffer a loss of control, no longer needs to be sudden, we've just established, can be over a period of time, but obviously, the longer that period of time, the harder perhaps it will be for the jury to accept. So it will be for the jury to decide. If it's hours, like with Ahluwalia, perhaps fine. If it's days, certainly if it's weeks later, this whole idea in the jury's mind that, you could basically, it's a cooling off period. You could calm yourself down. You're no longer having lost control. That could, as time passes, be a reason for the defence to fail. But it doesn't need to be sudden, okay? Secondly, there's now this introduction of what is known as a qualifying trigger. This is put into 2A and 2B. Now, both may be present or just one for it to succeed. Clearly, the law doesn't want to accept, as we mentioned before, certain situations that are excluded now, like sexual infidelity, but they tried to redress the bit with, domestic violence cases, abused partners. These fear of serious violence from the victim, just as Ahluwalia would have been against her husband, for example. Or indeed, if you fear another person is going to suffer serious violence, perhaps it's just, for example, your child that that your partner is, physically abusing. The second part is things said and or done that are of extremely grave character and leave the defendant to feel seriously wronged. Now, in plain speaking, things said or done, it should be, or done. Extremely grave character, it just means it's got to be sufficiently serious, so to be accepted that the defendant kills the victim, and it's left them feeling seriously wrong. So the key term here is it's got to be serious, sufficiently serious, and specific to the defendant. We'll look at some examples. but just off the top of my head, it could be, for instance, that if somebody is sexually abused and they're being, ridiculed or humiliated about that from perhaps the person who did it, then if the defendant then kills the person who's saying these things, given the context of that, I think it would be a sufficiently serious matter, and the defendant would feel seriously wrong to be having these taunts directed, this humiliation directed at them. And third, finally, because all three bits need to pass, this is an objective test. This is something clearly there for the jury to consider. A person of defendant's age and sex, so, their age and their gender, with a normal degree of tolerance and self-restraint, and in the circumstances of the defendant, might have reacted in the same way to the defendant. This, in the exam scenario, it is for you to give your own view. It may be different from somebody else's. That is entirely fine. Now, it's worth mentioning that the term circumstances can include, I think, mental illness. It can include sexual infidelity. So while sexual infidelity is no longer a qualifying trigger, if you will, a reason by itself to kill, it can be included there, provided your defence is arguing, one of the other two reasons. If you're somebody that is more likely to lose control or snap, be more angry, if you will, short fuse. I've seen exam questions reference that, sometimes. That is actually irrelevant to this defence. If it were a medical condition, it would be diminished responsibility. But in relation to loss of control, if you have someone that's more likely to lose their temper, notice it says a normal degree of tolerance and self-restraint, a person with a normal degree of tolerance and self-restraint, so that won't apply. So, key case, first of all, I'd use the case of duel perhaps for the first point about D must suffer a loss of control. Interestingly here, the defendant shot and killed the victim, fleeing the scene. He was later found in his car carrying a survival kit of items. So clearly, the jury weren't going to be convinced here that this is somebody that's lost control. This looks like a premeditated act of murder, and somebody, having a survival kit of items to, whatever it is, food, money, maybe their passport, whatever. The ratio is, for this defence to work, there must be sufficient evidence of a loss of control having been suffered. So let's focus on one of the qualifying triggers that the law will accept as a justified reason to lose control and kill. And what I like to do here is a Venn diagram. So I'll explain it first, and then you may like to pause it before the answers have gone through. So just focusing for a minute, you have a defendant that has lost control. The second element, there's two triggers. We're focusing on the second trigger, 2B. Things said or done that are of extremely grave character and left the defendant, feeling a sense of being seriously wronged. And I've got on the right hand side, numbered 1 to 11, a number of situations. Where would you place them in this Venn diagram? So for example, if we take number 1, you can just use the numbers. A crying baby. Where would you put a crying baby? Would it be things said, by the victim? The victim's the baby. Is it things said? Is it things done by the victim? Is it both? Or is it perhaps not of, sufficiently grave character and sufficiently leaving the defendant feel seriously wronged that it just wouldn't work for this defence of loss of control, in which case you would put it on the outside of the circles. So if you want to work your way through these, pause the video and I'll be going through the answers in a moment. Okay, just a quick sip of my drink there. And if we go through, so number one, I've placed on the outside. So clearly a baby crying, even if you were to suggest it's something that, if it's not language, it's something that babies do, things done, it wouldn't be sufficiently, of grave character, would it, to leave the defendant feeling seriously wrong. Babies cry, it's what they do. Interestingly, though, it was the case of, I think it's pronounced Doughty, 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 where under the old defence of provocation, that loss of control defence has since replaced, it allowed for a defendant who killed his crying baby because he was lost control for the very fact it was crying, and he got angry. They allowed the defence. So the loss of control defence now prevents this from happening, which is a good thing. I think we all agree. Secondly, abused by a partner, could be things said, could be things done. I think, like we saw with the Alawalia case, that would be sufficiently of grave character and leave you feeling seriously wronged if you were the defendant, like Alawalia. So we put that in the middle. Revenge is on the outside. Revenge is not a qualifying trigger. It is not something the law will accept by itself as a reason to kill. Why? Because it's premeditated, it's murder, isn't it? And the law doesn't want you to take the law into your own hands. That's for the police to deal with, and then the courts to determine. So revenge, no. You confront and kill a burglar. 4, we've got in things done. So the burglar has, done something by breaking into your house. And I think, contextually, you'd feel that's a sufficiently serious situation. You'd feel seriously wronged if that's been done to you. Perhaps you've got your family in the house as well. And so if you ended up killing, having lost control and killing that person, that could be possible for the defence. We've said that sexual infidelity is on the outside, so be very clear there. Just to say though, interestingly, an exam question may get you to analyse this. What level of sexual infidelity? It's really up to the jury, isn't it? But, is a kiss sexual infidelity if you kiss someone else? I think most people might say yes, it is. Obviously, anything above a kiss, perhaps it becomes clearer. What if somebody sends gifts to somebody? Like I said to my class, what if somebody sends a teddy bear to somebody with a heart that says "I love you," or sends flowers to somebody? Would that be sexual infidelity? Perhaps so, in the eyes of the partner who feels that they've been spurned by, been cheated on. But either way, if that is the reason that they've killed, or the juries see, the defence won't work. 6, you see your brother or sister being seriously assaulted. Well, that's things done, and we would agree sufficiently serious to be put in there as a reason why the defence might work for things said or done. Number 7, receiving a fail grade from your teacher. That is definitely on the outside of the Venn diagram circles, because it's not sufficiently serious. Teachers don't like giving fail grades. Excuse me, I'm sure you don't like receiving them either, but it's not a reason I think that anyone would accept it's sufficiently serious for you to kill. You might feel wronged, but that's part of learning and education, so you can't say seriously so. Number 8, you're bankrupt and your partner says you're worthless. Well, we could put that into things said because your partner said it. Interestingly, think of the context here, the circumstances bit. Remember the last bit of the defence said a person of D sex and age, or age and sex, with a normal degree of tolerance and self-restraint in similar circumstances, etc. Circumstances could include, for example, here that you're bankrupt. Now, if your partner says you're worthless, given the context of you being bankrupt, in the midst of that, that might be a sufficient reason why you lost control and killed. And so it would be grave in that sense. If a stranger came up to you and said you're worthless, and and you weren't bankrupt, for example, then I think it would be, much harder to prove. The defence wouldn't succeed then. It wouldn't have the same meaning, would it? Next one. Number 9, you are attacked with a baseball bat. Things done clearly to you, and therefore sufficiently serious to place it there as a possibility of the defence working. Then we've got number 10. Someone threatens to kill you. That could be they've said it, or maybe they've written it down, sent you a text, whatever. We'll put it in both, shall we? I think threatening to kill you is sufficiently serious and will make you feel seriously wronged. And relationship breakdown, well, that's on the outside. There's a case called Hatter, I believe, 2013. You may want to look it up. And clearly relationship breakdown, as sad as that is something that is, I don't want to say, well, commonplace, but is something that, is part of life. And so therefore it wouldn't be accepted by the court, or indeed Parliament when they legislated this, that it should be a reason for you to kill. Otherwise, you could imagine what society would be like if they did allow it. So just to refocus, the qualifying triggers, the excluded matters, the things that won't count, and you will have to look out for these in exam scenarios. The first being revenge, we said. It's not allowed in this defence. That's section 54, subsection 4 of the Coroners and Justice Act. For the reason we said, the law does not want you to take the law into your own hands, and revenge is just really premeditated murder, isn't it, in a sense? The second qualifying trigger, or actually, have I labelled these wrongly? I have, beg my pardon. So this says excluded matter 1, it should be excluded matter 2, and oh no, sorry, I'm right. I've lost myself for a minute. No, we're still talking about revenge. The case of Bailey, actually, old case, 1995, predates the loss of control defence from 2009, but is still useful because it illustrates revenge case. The defendant's son was threatened by a drug dealer, so the defendant drove to the drug dealer's home and killed him, taking with him, I believe, a shotgun and a razor. The ratio, the law coming out of this case is revenge, as I said before, isn't accepted. Right, now, correctly, I'm going to say excluded matter 2, the case of Dawes. Dawes, defendant returns home to find his wife asleep with a fully clothed man. Defendant begins fighting with the victim, and then, of course, when he realises he's not going to be successful, the man's successfully fighting back and sort of hitting him, he goes away, I think probably it was to the kitchen, and gets a knife and then returns and stabs him. He then tries to use the defence of loss of control, but the law is clear here. In fact, it explicitly states it in section 55, subsection 6, subsection A and B. And again, if you want to look up the law, just Google, Coroners and Justice Act and the section numbers, and you'll find the legislation. But if the defendant incites, in other words, starts the violence, so here the defendant comes home and he's obviously upset seeing his wife asleep with a fully clothed man. The man's asleep, he's not attacking him, he's not putting him in fear of serious violence or anything like that. So it boils down to things perhaps done. And things done, I mean, again, you could argue, did he perceive sexual infidelity? We know that's not going to work. But certainly the moment that he started attacking the man, when the man fights back, he can't then claim that's why I killed him, because you've started it, haven't you? Law's not going to accept that. Here's the big one we've mentioned so far, quite common in problem scenarios, it seems, as well. And this is the shown in the case of Clinton, the excluded matter 3. Defendant's wife left him, and the defendant suffered from depression. You can see from the picture the defendant on the far left and his wife on the right. She returned, and I think he tried to reconcile the relationship. They had an argument. His claim was that she had taunted him with other men she'd slept with. She didn't want to return home, and she also taunted him about his inability to commit suicide when he said, he was depressed and I think, thinking of killing himself. So the defendant killed his wife. Now, that was the defence that Clinton put forward. The jury were not convinced. Section 55, subsection 6, subsection C says that sexual infidelity isn't accepted as an excuse for loss of control. So it is a matter for the jury, and it is a matter for you in an exam question to decide, to give a view. And this was reported in the BBC News. You can see a link there. Without going into too much detail, I think what was clear though is when he killed his wife, he sent photos of the body to I think on the phone of the alleged lover that his wife was now with. So I think clearly the jury was satisfied in their mind that it was sexual infidelity that was the main reason for why he killed. His argument would have been perhaps it was the taunts about his failing to commit suicide when he was depressed, the things said, but the jury, as I said, were not convinced, and I think rightly so. Another key case, Asmelash. If the issue of intoxication were to be present in a scenario, same as before really, well, here we are, the defendant was intoxicated, murdered the victim. Intoxication is not relevant. So, like with diminished responsibility, you ignore intoxication if you're dealing with loss of control defence. You just deal with whether there is a loss of control and whether there is a qualifying trigger, and it's not one of those excluded matters, and so on and so forth. In a problem scenario for murder, particularly a 30 mark one I'm thinking here, you will find that quite possibly both defences of diminished responsibility and loss of control are there. Usually in a courtroom situation, I would say both defences can be put forward, but usually there is one defence that's more likely to succeed than another. And I think that's really, how the examiners look at it. But yeah, if they're both there, raise them. Right, scenarios then. So will the defence of loss of control be successful? Pete's younger brother Ross is threatened by a thug with serious violence unless he repays a long-standing debt. Pete is furious and drives 20 miles to visit the thug at his home. A fight starts and Pete punches the thug, who falls and hits his head and dies. Is Pete able to use the defence of loss of control? So at this point, similarly before, have the three elements of this loss of control defence outlined in front of you in your book or in your notes. It was on the previous slide we did. Ask yourself, is there a loss of control here? Well, it says Pete is furious, so that might well be an indication of loss of control. We know it no longer needs to be sudden. We're using the case of, I think, Jewel to say that there must be sufficient evidence put forward to the court. But it says that he drives Pete 20 miles to visit the thug. So though it needn't be sudden, it may be a question in the jury's mind that 20 miles has allowed Pete to sufficiently cool down to regain control and therefore not be able to use this defence. But that's really up to you and the jury, but you in an exam question to say, give a comment on, and just make sure you say the fact that it no longer needs to be sudden, but it may cast some doubt. Then we've got the second bit, a qualifying trigger. Now you're looking for one or both of those triggers. The first being fear of serious violence from the victim to the defendant, Pete, or fear of serious violence to another. Before we even get into the second bit, I think we could easily say that's here because Pete's younger brother Ross has been threatened with serious violence by a thug. So that qualifying trigger is present. You could try and argue as well the things said or done, certainly to the brother. Either way, both triggers look like they're there, certainly the fear of serious violence one. Any excluded matters that may prevent this defence, well, I would say that if it's in the jury's mind that Pete acts the way he does out of revenge, a bit similar perhaps to the Bailey case we discussed earlier with the father, finding out his son was threatened by a drug dealer. and then going off to kill the drug dealer, then that will mean the defence doesn't succeed. You should have in your notes, if we're following the way down, the next bit of the defence, which is with a person in the defendant's age and sex, with a normal degree of tolerance and self-restraint in similar circumstances, have reacted, in the same way. And I think most people would say in this instance, no, you wouldn't expect a person to go and do as Peter's done here. So overall, probably not. Revenge is going to prevent it. Jimmy is estranged, in other words, separated from his wife, and returns to the family home with a bottle of wine, hoping for a reconciliation to get back together. However, when he walks into the living room, he finds his wife and an unknown man asleep cuddling on the sofa. Angry, Jimmy swings the bottle at the man's head, who wakes up. He starts to grab Jimmy, who then swings the bottle again, killing him. Is Jimmy able to use the defence of loss of control? This is, as you probably gathered, a carbon copy of the Dawes case we just discussed earlier, and the fact that if you incite the violence, if you start it yourself, it is an excluded matter. So if we were to comment on this, the loss of control, is there one? We can say, yes, Jimmy, he's angry from the situation he sees of his wife being with this unknown man asleep. Is there a qualifying trigger? He could perhaps try and argue things done that are grave character and leave him feeling seriously wronged, but it all seems to focus on the possible issue of sexual infidelity. Maybe that's an excluded matter. That was the Clinton case, but certainly the Dawes case as well says that if you started the violence, you can't then use the defence. So nope, not for him. Anaya is in an abusive and controlling relationship with her husband, who regularly beats her. She's deeply depressed. One evening, after a violent confrontation, Anaya waits until her husband is asleep before hitting him over the head with an ashtray, killing him. Is she able to use the defence of loss of control? What we can say here is, we used this scenario, I think, previously in the context of diminished responsibility, but now for loss of control, we would say, yes, the loss of control need not be sudden. It can be a slow, cumulative build-up, slow burn. That's one way in which loss of control defences try to address, domestic violence cases that they were seeing, like Alawalia. Fear of serious violence would be the qualifying trigger, which I don't think I've put there. They've had a violent confrontation. I think fear of serious violence should be there as a qualifying trigger, as well as things said and done. And then you could ask yourself, any excluded matters. Is there revenge there? I don't see it myself. And then the last test of a person's sex and age. I think people, perhaps, again, it's your opinion, in that situation may well have acted the same if there was a threat. Then we've got Farhad is home alone caring for his newborn baby. The newborn baby, despite his best efforts, will not stop crying. In a rage, he throws the baby across the room, killing it. Is Farhad able to use the defence of loss of control? This almost makes you think of the case of Woolin, perhaps, that we studied in relation to causation and virtual certainty. But if you remember our Venn diagram, the answer is no. Loss of control, yes. He's if I click back, in a rage. But qualifying trigger, there's no fear of serious violence from a baby or to another, and things said or done are not sufficiently serious enough. So no. And Zoal, if I'm pronouncing that correctly, I apologise. Zoal has recently lost his job and fallen into a deep depression. His father regularly taunts him about this and his failure to support his family. Zoal snaps and bludgeons his father to death, so repeatedly sort of beats his father to death, perhaps with a blunt instrument or something. Is Zoal able to use the defence of loss of control? Well, in relation to Zoal, we can say that the loss of control is, well, the word snaps is quite useful. That shows a loss of control, perhaps. Qualifying trigger, I think it could be things things said. His father regularly taunts him. things said, and in the context of the failure to support his family, that would make somebody feel, that it's of grave character and sufficiently seriously wronged. Excluded matters, again, revenge, I don't see it, but you might want to raise the possibility. I think a jury would accept that qualifying trigger, and again, the last test, the person of defendant's sex and age, normal degree of tolerance and self-restraint in similar circumstances. In this case, the circumstances being the losing his job, being in a deep depression. I think you might find that people would accept that this defence, that is a justifiable reason for why someone may have killed someone. Notice the deep depression bit. Yes, diminished responsibility is relevant, but it's a different defence. We're focusing on loss of control at the moment. And Jake and his wife agree to have a trial separation. Jake falls into depression. After a few weeks, Jake attempts to reconcile with his wife, but she reveals she has been having an affair. An argument begins and she says she has been seeing a number of men. Jake in anger strangles her to death. Is Jake able to use the defence of loss of control? Again, carbon copy more or less of the Clinton case and the issue of sexual infidelity. So we can say, loss of control. Well, yes, there's anger there. Qualifying trigger, things said and done, perhaps. Trying to focus perhaps on the it's really difficult, isn't it? I mean, whereas in Clinton he argued it was the taunts about his inability to kill himself that was the things said that made him lose control. In this scenario, again, if I go back, we haven't got that. We've just got, she reveals she's been having an affair, an argument starts, she's seeing a number of men. So actually, I don't think there is a qualifying trigger there at all. And I think the excluded matter of revenge and sexual infidelity, I should have put, is going to stop this defence from working. Right, very long topic, I know. Thank you very much for listening, and I think our next video will be non-fatal offences. But thank you for listening. Good luck with your revision.